Hello.
Good morning, Your Honor.
Good morning. Sasaki is also present.
Yes, good morning, Your Honor.
Good morning.
Representing another, Candace Jones.
And put this on for a couple of different things. I have at least a proposed order.
Can y'all even hear me?
Yes.
Okay, awesome. Thank you.
So this is on today. It's set for to approve a petition as well as show cause.
Yes, Your Honor. For the last review, we had asked Commissioner, I think it was Commissioner Baldwin, to set it over as I had just been retained, but we're ready to settle all matters today.
All right, Mr. Sasaki, is that your position as well?
No, I wasn't aware that there was an agreement, at least as to petitioner and my client, but I'm of course, would like to hear what agreement may be in place with regards to the father and petitioner.
Okay. So can somebody enlighten me? I do, like I said, I have a proposed order, but I don't know that anybody has seen this.
And I don't know if I've seen it, Your Honor, and I apologize. I meant in regards to the guardianship. My client is in agreement to the guardianship. He just would like to have it somewhere noted in the findings that he is unable to have her due to the danger that she possessed, or I don't know how you want to phrase it, but he doesn't want it just like he gave up. He's in agreement for Miss Teresa for guardianship, and then I think for the issue of child support, we would have to do that another date, whether we set it or the guardian sets it for a hearing.
Right. Go ahead.
They all got the papers. All the lawyers got the papers that for the second set. They all said they did anyway. I had sent them to Lucas's lawyer and to Candace's lawyer. The papers for, I forget what they're called, permanent, I guess, the second set of papers you have there, not the emergency, but the next set also.
Yes.
But the only one that I have is the emergency order.
And then you said you had I thought you said you had another order in front of you for, let me look at that.
So, Your Honor, if I may clarify,
go ahead.
help clarify, I apologize. So, the petitioner has properly served all parties with her regular guardianship petition. And with regard to both the emergency and the regular petitions, we've already filed our objection to the emergency guardianship and plan on doing so for the regular guardianship as well. I just need some additional time to work with my client on getting those forms filed and served.
Okay.
It's already.
So I think I just saw our Ms. Turnbull.
Yes, Your Honor, I'm here.
Hey, good morning.
Good morning.
So and correct me if I'm wrong, what I'm understanding is that that Mr. Wittig is in agreement. Let's proceed forward. Ms. Jones is opposed. And so we're likely going to need to set a hearing on those, but Mr. Sasaki is indicating he needs to file a response to the permanent, which I am not seeing in the court file yet either.
Your Honor, we filed an objection to the emergency, and we're working on our objection for the permanent. full guardianship.
I see that. What I don't see though, let me just check here. Okay, I do have the petition on the permanent as well. Okay, so those are all in the file. So we just need your objection on that one.
What are we objecting to?
So good question. If I may answer that. So we're objecting just to a couple terms on the petition. Primarily, it's the child support, and the petitioner has indicated in her petition that she would like child support set at an amount as per the child support worksheet. And secondarily, we wanted to leave visitation open at the minor's discretion in resumption of visitation, video visitation, at least with my client.
I believe
mother.
that's on there, sir. That it was, I believe I agreed to that.
You're correct in that it was noted on the residential schedule. However, the petition itself does say no contact.
Mm.
And so I just wanted some clarification on that. And
I
with
don't have a
regard
problem
to
with them talking to her. Sorry.
understood, thank you. So if just with regard to the child support, my client's employment situation is currently in flux, and if we go at the the child support worksheet with this month's income, that amount is going to be about $50, and so we I think would be okay with that, but so far our negotiations have not been fruitful on that point.
Okay. Ms. Turnbull, do you have any comments on this one at all at this point?
Not at this time, Your Honor.
Okay. So if maybe see if I can encapsulate this. It sounds like there's essentially an agreement as to the guardianship, as long as the visitation, at least with mom, is sort of an open, up to the minor kind of language. And then we maybe just need to have a review hearing with regards to child support.
That sounds correct to me, Your Honor.
Okay.
Yeah.
So maybe the best plan of action, since we haven't got an official objection filed yet, and my thought would be is to maybe set this out either 2 to 3 weeks, see if council and Ms. Lee can put together essentially an agreed order on everything, leaving at least a blank for child support, and then provide the court with some financial documentation, and I can certainly make a decision on that if it's not agreed to.
That would be agreeable to me, Your Honor.
Okay. So why don't I do an order extending? And Ms. Turnbull, we're probably at this juncture, I don't know that we're going to need a whole lot more from you at this point. It sounds like we've got everything kind of in place. If we shot for the 4th of June, that's 3 weeks, that would give an opportunity for everybody to hopefully get together and come up with essentially an agreed order. If you come up with an agreement on the support, that's fine as well, obviously. But if not, then I can certainly address that when we come back on the 4th if I have some documentation on that.
Your Honor,
You wanna
do you
listen?
guys, I'm sorry.
Go ahead.
Do y'all only do these things on Tuesdays? Do you do them on Mondays?
We're always on a Tuesday.
Okay.
The only other option, I could put it on the other docket, but that would be a Thursday. I'm not sure if that's a better option for you. That's not me.
I'll just make it work. It's okay. I'll make it work.
Okay. I mean, if you need to have it a little farther out for scheduling purpose, we can do that as well.
No, it's okay. It's okay.
Let's go to the 4th at 10:30. And if council, if you can all get together and put together some agreements, at least on a general order, leaving a blank for the support if that's not agreeable, and then we can address that on the 4th.
Your Honor, do you want to include my discharge at that time in the order as well?
I'm sorry?
You want to include in the order my discharge as well, if you don't think that that you're gonna need my services anymore?
Council, do you see any need for our visitor to continuing on at this point?
No, Your Honor.
Unless it were to go to trial, then no, I don't believe so. Yeah, I don't believe I can include that in the orders and can draft those accordingly.
Okay, so Mr. Turnbull, what I'm going to suggest, we'll put that in whatever the agreed order is, but I wouldn't have you appear at the next hearing unless you're on docket anyway.
Okay, that sounds good. Thank you.
All right, so set it the 4th at 10:30. I'll do an agreed extension of that order. And hopefully we'll have a final order we can enter on the 4th. All right.
Thank you.
Thank you, Your Honor.
You're welcome.
Thank you.
This one I just had, where are we at as far as service and status and?
Nowhere.
Well, in terms of the mother's status, we're filing the objection to the minor guardianship, and that went in the mail today to all the other parties as well. So we're up to date on that at least, and I'm not sure about where we're at with service.
All right, so let's see here. Send it here. As far.
Good morning, Your Honor.
Good morning.
The petitioner, I cannot pronounce her last name, Kilowitz. Ms. Kilowitz, she hasn't been in touch with me, so I don't have any information about the service on the father.
Excuse me, Your Honor.
Yes.
I have been working with Miss Powers, Samantha's attorney, in assisting me with trying to locate Samantha's father. I had sent an email to Miss Farr scheduling an appointment to go over what the next step would need to be if we needed to do mail service or the newspaper posting, and never received a response. So I've just been working with Amy Powers on that. And mother was served with the petition. I had turned that in. I'm not sure why it didn't get posted. So I recently was able to get in contact with the person who served her with the full petition. He had had an emergency heart surgery. So I've gotten that refilled out and I will be turning that in today. We know that Corianne is aware of where her husband is, but we have not been able to locate him as he is listed as transient, and she's the only one that I know of from people who have said that he's been visiting her.
Your Honor.
Including people who live in the house.
Your Honor.
Well, Corianne, let me take care of it, okay?
Okay.
Thank you. Yeah, no, Corianne doesn't know exactly where he's at. She was aware that he was in a certain area of Kelso or Longview, and now he's hanging out in Kelso on the north side, apparently.
Yes.
And maybe he contacts her, but she doesn't know where he's living, and she was going to offer that information today about where, at least what she knows. But as far as the exact whereabouts, she has no idea. He lives from couch to couch, I think, is the impression I get.
Mm-hmm.
According to my grandfather, he told me that she knows exactly where he's living and who he's living with.
No, he was, but he's not there anymore.
Okay.
He was with Larry.
Oh, well,
not there now.
okay. So Ms. Cowitz, I do need to have you connect with Ms. Farr so she has some things she has to do as part of the case, and that includes touching base with you. So maybe the two of you can connect after court, find a time you can chat.
Your Honor, Amy Powers. I am the attorney for the child, Samantha. At our last hearing on April 23rd, my understanding was that the petitioner was going to move towards publication. I think it's appropriate for me to help with that because my client's position is that she wants to remain with the petitioner, and I recognize service as an important step in that process. It sounds like I need to have more communication with Ms. Kilwitz because I'm still missing some information that I need before I could even file a motion to publish against the father, but I can work on that communication.
Okay. So maybe Ms. Powers, you and Ms. Cowwitz could touch base, connect with Ms. Barr as well, so she can finish up what she needs to do. How much, I guess we're gonna need to set it out again, how much time, we've got an objection coming in from Mr. Esau, and from Ms. Martin. They said that was in the mail today?
Yeah, it's in the mail today, Your Honor. It should be it from Arizona. It takes about 4 days. So
Okay, so that'll take a little bit of time. So
Yeah.
probably at least a couple of weeks then, before we, and then if you're gonna have to, well, if we put it on for the 28th, will that be sufficient time to get any motions noted?
I think that that will give me enough time to talk with Ms. Kilwitz and draft up a motion for publication. I assume I can just submit a motion to publish ex parte. So my goal would be to get that submitted before our next hearing.
Okay, do you want to go to the 28th or the 4th?
I would prefer the 4th if possible.
Okay. Any objection to that date?
no objection to that, Your Honor.
Okay, so we'll put it on at 10:30 on the 4th of June. And I'll do an order up to that effect. Okay. And again, hopefully you could both connect with Ms. Barr, so she does have some things she needs to do as far as the case goes in order to complete her duties as well. Okay.
Your Honor,
Yes, ma'am.
as I told my lawyer before, Mr. He was my parents knew he was living on Columbia Heights. He is no longer there. So my dad does not know where he is either, and I do not know. I don't know where Natalie got my dad saying I know where he lives, because I didn't even know exactly where he was up on Columbia Heights either. So That's not true.
Okay. Nobody's saying it is true, so at this point.
Well, that's what she's implying.
Okay, well, at this point, we'll come back on the 4th and hopefully we'll
Okay.
be further along.
Okay.
Your Honor, would you like me to send over an order extending?
That'd be great if you've got time to do that. That would be helpful.
I will do that.
Okay, thank you.
All right, thank you, Your Honor.
Thank you. Veselak matter?
Yes. Good morning, Your Honor. Counsel for the respondent child.
Amy Powers here for the petition. Mr. Keaton is present in my office with me as well.
Good morning, Your Honor. Attorney Dino Goyek here on behalf of the mother.
Good morning. So I do have an order that appears to have a lot of signatures on it.
I'm not sure what order you would have. My understanding is that we've been waiting to see if Ms. Barnes will consent to the minor guardianship. We were here on April 16th. Ms. Barnes has not filed a response yet, so in all accounts, it sounds like she's going to consent, but she has not filed a response, an objection, or a consent in this matter. So I feel like we're a little bit stuck until that happens. I'd ask the court to set a date certain that she needs to file some sort of response. Otherwise, we may consider a motion for default, pursuing a motion for default.
Okay. The order I have was one, it looks like it was provided by your office with signatures from Diana Peden, John Peden, yourself, and Austin.
Oh, that's probably the emergency minor guardianship. We had submitted that for our initial hearing way back when we filed the case, but we still don't know Ms. Barnes' position, so it hasn't been addressed yet.
Got it. Okay, that's the order I had. That's what I was referencing. So, okay. Mr. Gozak, do you know when we might see a response?
So, Your Honor, I will turn that over to my client who is present here today to let us know whether she wants to consent or object to the guardianship. I can try my best to try to get something filed with the court, but I have not been able to get an answer one way or the other.
Okay. Ms. Barnes?
I had talked to my attorney a little bit, and I did not, I consent to the guardianship. I just was kind of wondering why there was all that other stuff put in there that's no proof that I've neglected my child or anything in any way. But yes, I do believe that the best thing for her right now is to go with Diana
Okay.
for, the time being.
Okay. So
I had a family emergency come up, and that's why I haven't been able to connect with my attorney too much.
okay. So I'm wondering on this one, and Ms. Turnbull is also involved in this one. And it would seem to me maybe what we could do today, based on Ms. Barnes's verbal agreement to proceed forward, I could enter this temporary order, which is the temporary guardianship, and then we can set out, that gives us a little more flexibility time-wise to put together consents and everything else for a final.
That sounds good to me, Your Honor. And Ms. Barnes, I will send out the consent form to you to hopefully sign.
I would be in agreement with that as well.
That's what
Same, Your Honor.
Okay, so well, what I'm going to do, I've got this order. It was signed by everybody except Mr. Gojak and Ms. Barnes. I believe Mr. Lee, I don't know that you signed this.
No, this was prepared before Mr. Lee was appointed.
I see. Okay. So let me just have a look here. So looking at the wrong order. There it is. Looking at the wrong. No wonder something didn't look right there. So let me see here. So it looks like I do not have a signature from Alana either.
No, that's the child. Would the court want me to just send an updated version with signature lines for everybody on it, or would the court be willing to write in approved via Zoom for Mr. Lee and Ms. Turnbull?
I'm fine doing that. Mr. Lee, are you agreeable to that process moving forward?
That is just fine, Your Honor.
And Ms. Turnbull?
That's fine.
Okay. How much time do you think you want in order to get work on final paperwork?
Maybe a month out.
That would be just fine. I can do final paperwork and circulate it to the parties at the same time that we're waiting for the consent to come in.
Okay. How much time do you think? I didn't catch the date, the time.
Mr. Gojak suggested a month out. I don't need that long, but it's fine if it goes out that far. That would put us to June 11th.
Okay. Let's put it to June 11th, and then this is another one where probably, as long as we have a consent from everybody, again, Ms. Turnbull probably doesn't have anything else we need to do in this case. I'm assuming. So we'll put it on for the 11th, and I won't do a separate order extending. We'll have the temporary order, which will be in place until we come back on the 11th.
Okay, can I just confirm on the order on emergency minor guardianship, which you just entered, did you add an expiration date on the first page under 1 for when the letters expire?
I did not, but let's see here.
I believe it's usually 60 days out.
We don't have a trial date set, and we can go to the date of the regular guardianship, but let me see here just a second. I'm not seeing the expiration.
I believe by statute, emergency minor guardianships are generally granted for 60 days.
I understand that. That's if you don't have a hearing set on the general. So I'm going to put review on the 11th. 11. So I'll put out 60. So if we go to the, how about the 2nd of July?
Okay.
So I've added that paragraph 10.
Thank you. And was July 2nd also added on page 1?
Well, I set a review date on June 11th, which was when we're coming back for the review date.
I know it's just under the next section. It says child, child's name, and then letters expire. So I think that the date is also supposed to be included there.
Which paragraph are you looking at?
On page 1, within the boxes, there's date guardian appointed, and then child's name, and then next to the child's name, it says letters expire.
Oh, got it.
Yeah.
Okay, so that was the 2nd. Okay, so I've added that there.
Thank you.
Okay, let's send that order, then we'll be back on the 11th, and hopefully we'll be able to get a full order in place.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
And Ms. Barnes,
Thank
I'll
you.
give you a call here right after court.
I don't think I'll set a hearing yet. We'll take a look on when we come back on the 11th if we need that. Okay. All right, thank you. And Ms. Turnbull, you are involved in this one, it looks like.
Yes, I am.
And where are we at on this one?
Well, I've connected with Ms. Miller and reviewed the case with her. She does. She's working on getting me the birth certificate. My understanding is father is not on the birth certificate, and so that would cover the issue of serving father, and mother is in agreement with the guardianship.
Okay. So we just need to get those documents so you can, excuse me, so
Right.
you can verify that and then we can move forward.
Correct. And Ms. Miller seems to think that she probably would be able to have the birth certificate today. When we spoke this morning.
I'm sorry, excuse me. I just heard back from the PCAP worker that's helping me, and I could pick it up tomorrow at 2.
Tomorrow at 2. Okay.
Yep.
So this one we could probably maybe a couple of weeks. Is that sufficient? Okay, so let's put it on for the 28th. So I'll do up an order on that one. If we did we have a consent in this one?
Let me look at my notes.
I don't see one.
The consent was filed at the initial filing.
I wonder if that's part of this petition. Let me check.
That sounds
It is part of the petition.
petition.
Okay, so as long as we've got verification he's not on the birth certificate, we'll probably do final orders when we come back in 2 weeks.
Okay, fantastic.
So Ms. Miller, I'll need to have you be in touch with Ms. Turnbull, get her the birth certificate, and then we can get final orders prepared and we can get those submitted prior to that hearing. I can go out another week if you think you need more time, but that we could be able to get this one resolved for you.
I'm good with, I mean, from what I understand, I'll be able to pick it up tomorrow too. Everything's been filed, so sooner the better.
Okay, so we'll go for the 28th at 10:30 and I'll do an extension order to that date.
Okay. And Your Honor?
Yes.
Can you mail me those documents again? That's the only time I've received them is when you actually mail them. I don't know why I can't get them through email.
Oh.
But if you can mail me the orders again would be great.
Okay. I will have my staff send out an email version of that order.
Okay, thank you so much.
Okay. Anything else on this one?
Nope.
I don't think so.
Okay, very good. I believe that's all we have on the docket today. So we will adjourn and we'll see you all. I will not be here next week, but I'll see you in 2 weeks. 381-0.
Very good. Thank you, Your Honor.
This was on for, you're welcome. Review to see if the Guardian litem report was filed, and it has been. I believe that was Question about more time for the guardian. Don't see Miss. Not seeing the guardian here yet.
Your Honor, if I may?
Sure.
I might have missed the beginning of this proceeding. The court's now called Gall. We're addressing that now.
I just called that. I believe we were on for a review to see if the guardian litem report was filed. There is one. There was also I think a question about whether there needed to be more time. But I don't see our guardian here yet, so we'll come back to that one.
Thank you.
So I think from our end, Judge, I don't know that Mr. Thompson is on the Zoom roster if he's retained counsel. Nonetheless, we're ready to go today.
The affidavit of service is referencing the wrong case.
So he was served in the Midwest. We know he got served. I have been in touch with an attorney on his behalf.
So the service, the affidavit of service references a case number 17-3-1940. I don't know if that's
well, if you look at the affidavit of service again from the state of Wisconsin, do you have a copy of that, Judge?
That's what I'm looking at, and it's one that references the wrong case number.
Yeah, and that might case number 7. Yeah, and again, that's the hard part with that, is that's a process server in Wisconsin. So my guess is they probably used that from an old form. They just didn't update the information. Nonetheless, I don't think that's critical. I don't think there's any question he's been served. I have expected the attorney to appear on his behalf today. Everybody knew the hearing was set. There's been conversation between he and my client's adult daughter about court, about everything that's happened in the motion. He's essentially cut off payment of my client once he was served on April 16th. So if you look at the body of that information, that affidavit of services you're referencing from Mr. I believe his name is Haldeman, states clearly that he served a summons, the notice about a marriage, petition for divorce, temporary family law order, financial declaration, division of assets, financial source documents, and family law calendar notice that occurred to Thompson. So that is what it is. Affidavit of service, again, cover sheet is the correct cause number. It's this information that came directly from Mr. Haldeman that I think inadvertently or incorrectly put a case number in that isn't ours, but nonetheless, I don't think that's fatal to everything that was served upon it.
You said there's somebody who's appearing. Is anybody appearing on the behalf of Kurt Lyndon Thompson?
Why don't we come back to that? I will send you a text message to the attorney that I was in contact with last week about that.
Okay.
We can revisit this.
Okay.
As soon as I get an update on that.
Okay. There's a lot of questions on that one. See, there's some, I guess, well, it's going to be a complicated case from the looks of it.
There's a lot going on. Yeah.
Wait.
I'm not ready.
Is Nicole Walker? No, Nicole Boivio.
Yeah.
Good afternoon.
Judge, I can expedite this for everyone. We did receive Ms. Boaglio's reply declaration, and I believe she emailed to my office late yesterday afternoon. In reviewing that in anticipation of today's hearing, I did see that there was a comment about a conflict in my office. I looked into that, and sure enough, my office, not me, but another individual who's no longer an attorney in my office, met with Ms. Boaglio, it appears in 2019 or 2020. I don't have it in front of me, which I do think constitutes a conflict of interest for me. I'm not comfortable proceeding based on that.
Okay.
So my recommendation today, I've already been in contact with my client about 20 minutes before court began about that. He understands, certainly is aware of that now that that's been raised. He's going to seek alternative counsel. I've given him various names of suitable and reputable attorneys in the area that I anticipate he will meet with within the next week or so. Okay. Issue with that is the settlement conference that currently is scheduled for Monday. So if the court is inclined to keep that date, we'll rush and do what we can with that. There's also the issue of the GAL appointment that is, it doesn't look like anybody disagrees with that. My suggestion is we simply strike that settlement conference. I'm not sure how productive that would be given the circumstances. And appoint a GAL and simply just reschedule and get another date or sometime this summer to hopefully get this case resolved through mediation.
Ms. Puaglio?
Yeah, I am not opposed to a guardian ad litem, but also I feel like I'm prepared to go to the settlement conference and possibly make some changes. I'd rather not continue to draw out things with court, and I'd really like to see Caleb get a schedule that's going to be consistent and find something, a way of just to stop this kind of continual revisiting in court. And I did file a statement with the court, and I sent to Chad Zandy's office about a week ago with my response to this, and just saying that I agree that yes, we could have a guardian ad litem, but I would prefer to just go forward with the settlement conference if that's possible.
Well, it's possible to leave it on. My suspicion is you will probably not accomplish a lot based on all of the, and I reviewed at least some of the filings with regards to today as well as the whole case. If you think that there's a possibility that we can move things forward at that, we can. I think it's scheduled. What time is it scheduled on?
I believe it's 1 o'clock Monday.
I think 10 a.m.
Yeah.
I mean, we leave it on if you think there's going to be progress. Parties can meet.
I know my client initially when we met, of course, I'm new to this case as well. My client and I initially met, we wanted to have representation at that settlement conference, which I certainly understand can be somewhat overwhelming to pro se. I would obviously prefer that. I think it would make sense to have counsel present. I just can't step in and put myself obviously with the conflict in that position, and I can't put myself in other attorneys who my client might confer with over the next several days as to what their availability are. So that's kind of where I'm at with it. I think these 2-hour slots, again, are certainly something that's beneficial and useful for these parties. But again, if we don't have a GAL investigation, we don't have a recommendation, we've got 2 parties who are sitting in separate Zoom rooms going back and forth, not knowing the process well or having any kind of a recommendation. I think it kind of defeats the purpose and honestly becomes somewhat of a frustration. So that was my position in asking that be, get some input from a GAL, which the court is certainly going to appreciate, especially with 2 pro ses. Get that information and then come back in a month or 2. I think that would be much more productive, and there'd be a lot more to base any settlement proposals off for both parties.
Okay. Well, I mean, given I guess the timing on Mr. Zandy having to step out of this, I am inclined to strike Monday just simply because of the, I mean, this is a fairly significant request, which is unlikely to be addressed at that settlement conference. I don't know, there's a number of items that apparently this is a modification. So my thought would be to strike Monday, get another attorney on board, and then we can try and get you guys set. If it looks like that's a reasonable way to move forward, we can get that set relatively quickly.
See that be a bench order, Your Honor, since I will no longer be representing my client.
Can we just do that in a docket? Do we need an order striking or?
No, we can't.
We can just strike it from a docket.
Thank you.
So I think given the circumstances, I will strike that based on you're not going to make a lot of progress because he wants his attorney there and he's not going to have an attorney in time. There was a couple of different ones. One is a motion for contempt also. And obviously you can't handle that on behalf of your client.
No, I think certainly the line should be that I don't argue that. I'm aware of it. I, again, went back and looked to make sure everything here that were conflict, if you do go back and retrace your steps. I was at the onset of COVID. That was when there was 3 attorneys in my office, and one of them, you know, the one that saw Miss Walker is now gone. So I don't have any inside information from that. But just given the bird's eye view of this thing, I just assume not argue anything that could have been subject to any communication between Miss Gilmore and Miss Boaglio, because again, I think that crosses a line. I wouldn't do that. So I would ask that the contempt matter be continued, or whatever the court deems is appropriate for that, so that again, my client can be represented as he needs to. And we did receive, if this is any consideration, it looks like we received by mail. I misspoke earlier, as an email. When we received by mail, Ms. Boaglio's reply declaration yesterday. It looks like that was filed on May 1st. So I would like to review that. It's a former client to review that. It's about 7 pages. It has some exhibits.
I have a receipt from the, this is when I mailed it, was May 1st. That's me mailing his papers to his office. I was told it would be there the next day.
There it was. So again, I give the circumstances, so kick this out 2 weeks. My client has somebody else represent him, or even a week, because everything's done. They can just argue off of the existing pleadings. I think that would be appropriate.
I recall seeing this in here when I looked at this. Yeah, I mean, so here's my thought on this thing. Would be to set everything over a couple of weeks, address all those issues at the same time.
That would be the motion to appoint the GAL and the contempt motion.
Yeah.
Okay.
So I can either do, and I'm going to, Ms. Boaglio, I don't know which, would the 28th or the 4th work better for you?
I'm on my phone, so I'm wanting to pull up just to see what day of the week those are.
It's a Tuesday. It'd be 2 weeks from
Tuesday.
Okay.
Today. Honestly, either one's fine, but I would say the 28th, just because getting into summertime, it's getting close to when my kids and I are doing a little more activities.
Okay, let's put it on for the 28th of May, which is 2 weeks from today at 1 o'clock.
Very well. Again, Ms. Boaglio, I apologize for the confusion on that misunderstanding.
Thank you. Thank you.
Okay.
Yes, Your Honor. Numbers 1 and 2, Ramos and Ramos.
Yeah, this was, we left this on for review. I know there's some other matters pending that are over onto next week.
Yes, Your Honor. We're just gonna continue it actually, and continue the ones next week as well till the 28th when Miss Baldwin's available. We're doing just gonna extend them. We're doing a little bit of a carve out in the Shirley, Ramos v. Shirley, to allow the boys to go visit their father this weekend because they are almost 18. We are super close. On the other one, I think the GAL is present here. We're going to do a carve out to allow reunification therapy with Charlotte Rosen to begin. I'm not sure. I don't see the GAL, but my screen is completely full. So hopefully she is here.
And I think Ms. Baldwin and Ms. Winkles have been back and forth to finish up that language to present an order for the court today. I think we just asked that everything be over to the 28th. They'll provide the order for signature, and the parties are working towards trying to come up with a resolution on all matters. Hence the.
So both matters, which would be 8 over to the 28th.
Yes, Your Honor.
I believe there are some matters that are on for next week, and you're asking to strike the hearing next week or set that over to the 28th as well?
Set them over as well.
Okay, so everything will be, there'll be no more hearings till the 28th. And then if you send over an order, we'll be happy to sign it.
All right,
Perfect.
thank you.
Coming
Thank you,
back
Jeff.
to the welcome Gall and Gall matter, I think I saw Mr. Gall log in.
Good afternoon, Your Honor. I'm here.
Good afternoon. And do we have Miss Corey?
Your Honor, before we start, I wanted to ask the court, I attempted to reach an agreement with the other party regarding setting this over for next week. Charlotte Rosen is not available. She got called away for a funeral and has other work duties, and she would like to speak to this matter and has made herself available for next Tuesday, when we also have other matters regarding this specific case.
Well, the only thing that's on today was to review whether we had a guardian ad litem report.
Okay, so
Mr. Curtin, is that your understanding?
That's my understanding, Your Honor, and I don't see any reason for continuing this hearing. It's just a review to make sure that the GAL turned in her report as instructed by the court.
Looks like Miss Corey is just coming in. Let me just check with her, because when I looked at that, my only question in that is it looked like there may be some.
there is some information that Ms. Rosen would like to add as a result of Twyla's report. Ms. Corey's report was filed at the last minute Friday afternoon, and I could do nothing to respond to it other than to forward it to Ms. Rosen. Ms. Rosen feels very strongly that she needs to comment at this point. And I would like the court to consider that, since the court is the one who appointed her the reunification counselor with all rights to direct reunification.
The only thing this is on is to see if a report's been filed. There has been a report filed. There's no motion before the court today. And my question was, Ms. Corey, I think you just logged in.
I see her.
I did. My apologies.
And I guess my question on this was, maybe I'm confusing, this was a different case. Were you looking for more time for an additional report, or is this your final report?
That is my final report. However, I had just massive amounts of trouble accessing the kids' mental health records, and they started coming in yesterday by fax, and they're in about 7 different files. So I need to go through them and put them in the correct order before I can really take a look at them. And what I thought and what I wrote in my report was that if there was anything that affected the report, that I could file a addendum to that, if that's okay with Your Honor.
Okay, that's what I was trying to understand. If that's kind of where we're at, that's fine. I think there is something else set for next week, but this was really a check-in to make sure we had the report, which we do.
Okay, Your Honor, there is the matter of payment towards Twyla and Ms. Rosen for next week. And at that point, I would like to ask Ms. Corey if she would consider the children's Xbox accounts where they're recorded playing R and X-rated games into a report.
Well, that would be something on to be considered next week, because today was just to make sure there's no other motion pending today that I could see.
I apologize, Your Honor. It's hard for me to follow these rules.
So and we do have a report. If you want to do an addendum to that, that would probably be helpful. If there's additional information that's going to be useful for the court.
I will try my best to have something into the court by next week.
Okay.
And that's next Tuesday, 1 o'clock also?
Tuesday at 1, correct. All right, and Mr. Curtin, that you were just on for just status, and I think there is something else set next week. I haven't looked at that, but that's, we'll deal with that next week.
I didn't quite hear, Your Honor. If you could repeat that.
I believe there is something set for next week. I'm not.
That's correct. Mr. Gall submitted a motion for distribution of trust funds. I filed a response. I haven't received a reply yet, but it's set for next week at 1 o'clock.
Okay.
I'm sorry, Mr. Curtin, I don't have your response yet. Could you please email that to me?
Well, Actually, it was sent, I can double check, but I believe it was sent by certified mail as well as regular mail. And I think there's a proof of an affidavit of mailing in the court file.
I would check, but I travel too much. It would make it easier if you could help out with this matter, but it's okay if you don't, sir.
My understanding was you work at home and the post office tried to deliver it to your house and no one picked it up and no one picked it up the next day at the post office.
Your Honor, I will see you next week.
Okay. There's nothing pending before the court today. So
thank you, Your Honor. Have a wonderful day.
You as well. So strike that, and then Ms. Corey can provide her update as needed. Thank you. Review.
Thank you, Your Honor.
Guardian litem report. Almost. Don't see Ms. Lawrence here. And I don't think we have a report.
Your Honor, I think she, I'm not even sure if she's here, but I think her investigation had to be put on hold. But me and George have come to an agreement regarding custody and the children.
Okay.
We want to do it split right in half, where we get both get the kids equal amounts of time.
Okay, so if you're gonna, whatever you come up with, you probably, because we have a guardian involved, you should let her know what your proposal is, and then she can weigh in on that. And if you've got an agreement, that's probably what we'll go with. But so
we request to pull the case out of the courts because we can get along and get this done for our babies.
Why you strike? I can strike any hearings at this point, and then you can renote it if you need an order entered, or if you haven't agreed, it can just be presented.
I think we're pretty like we're both want the kids equally. The only issue is that there's a protective order on the kids. He's unsure of how to drop that. Are you able to help him with that and strike the protective order with the babies?
I can't do it in this case. That needs to be a separate matter. What I'd suggest, sir, if you've got some legal questions, if you show up on a Monday at 12 to 2, is that the time?
For legal assistance.
Yeah.
Mondays from 12 to 2, yes.
Mondays from 12 to 2. We do have some lawyers who are available at the lobby of the courthouse. They can give you some guidance how to do that.
Okay, Mondays from 12 to 2, and we can't do it here, right?
Yeah, I don't have that case in front of me, so.
Oh, okay.
Your Honor, this is Casey Linney on behalf of the State for Child Support. Now that the parties are discussing a potential agreement, state is wanting to know if they are planning to enter a child support order or if they are just looking at doing a parenting plan at this time.
I'd like to take out the child support order. I'm no longer seeking support.
That answers the question. Thank you.
Yeah, once it's equal, there's no point in doing that.
All right, well, I'll strike the hearing today, and then we'll wait to hear from you what you'd like to do. Let the guardian litem know what your proposal is so she can determine if she needs to do any more work on the case.
Okay, thank you, Your Honor.
All right.
Thank you, Your Honor.
Welcome.
Your Honor, for a review hearing on July 16th. Assuming it's a GAL final report hearing.
Leave that on.
Awesome, Judge. So they
Mr. Zandy.
Discuss with the attorney, and this person has not been formally retained and has no authority.
Okay.
So that's where we're at.
Do we have a Mr. Kurt Thompson anywhere on Zoom? Not here present.
And Judge, I'm actually appearing on that matter. I just sent Mr. Zandy a text message. Sorry for my delay. I was just retained by Mr. Thompson.
Okay. Great.
So at this point, Judge, we are asking for a continuance, being as I've been officially retained as of 5 minutes ago, and I have had no opportunity to review the file or prepare for today's hearing.
Mr. Zandy?
So this is now, and I certainly understand that we've unfortunately all been in that position from time to time. This is a case where this court saw there is a separation contract that's in effect. Parties were going under the terms of that up until April 16th, when Mr. Thompson was served, at which he responds with, fine, I'm essentially cutting you off. It's been a month since he was served. We haven't heard anything from him. There's been nothing that's been filed. The support date has clearly been set. The motion cites, in my client's words, dire straits as it pertains to financial relief. And here we are, not just on the day of the hearing, but 27 minutes into the hearing, and he finally retains counsel. This is some of the issues we have with this individual, is the gamesmanship and some of the game playing measures that he does. This is further evidence of that. If the court is inclined to set this out a week or two, I would ask that you require him to pay my client. You can see this is a 25-year marriage. This is a case where he makes exponentially more than she does. And this is a case where he's literally spending thousands upon thousands upon thousands of dollars on pornography and video games. So if he has money to pay for pornography and video games, the capacity he does, he can give his wife of 25 years some kind of financial assistance so that she can piece together where she's at currently from whatever you set the hearing over to. So we would ask for $2,000 to be transferred immediately. It's Tuesday. I would ask that that be done by no later than Thursday at the close of business. But also ask for a contribution in attorney's fees and costs. Again, this could have all been avoided if you would have picked up the phone a week ago or emailed me or sent a letter or anything else and said, hey, I'm retaining counsel. Can we please talk about setting this over so that I'm not here forced to prepare for my time with my client who's not here when she could be doing other things. Again, 28 minutes after the fact of when he was supposed to be present. So we do believe that an award of fees and costs is appropriate. My client certainly needs some money to pay the mortgage, pay the utilities, and do those things. He up and left, leaving her with very little financial assistance, and then gets served and says, I'm cutting you off at the knees and time. That's where we're at. That's the request, and I think it's certainly reasonable given the circumstances.
Ms. Bliss?
And Judge, as I indicated, I'm real fresh into this case. I have no documentation from my client at this point. I've just been paid a retainer. It is my request to set this matter over at least a week. I understand and appreciate Mr. Zandy preparing for court today. I'm doing the best that I can on behalf of my client and trying to minimize any sort of detriment to him. So I'll defer to the court on the request, but I would just ask for at least a reservation pending next week or 2 weeks for the set over so that we can provide all of the information to the court that would be necessary.
And I would request 2 weeks, Judge. I am out on vacation, taking an extended weekend this week from Thursday. I will not get back till Monday. So assuming responsive pleadings do come in during that time, I'm not going to be able to turn around and reply. So I would ask for the 28th, if that's still open, we do that. But again, it's not about my vacation schedule. It's about my client's ability to try to pay the bills and make her life manageable at this point.
Well, this one's going to take, it's going to be a lengthy hearing when we get to it because I tried to make sense of the financial declaration and I was unable to do so. So, but what I will do today is I'm going to order that he pay $2,000 and that needs to be transferred. However, do they have a bank account they can do that through?
Sure they can.
Okay. So $2,000 no later than Thursday close of business. That's Thursday close of business here. That's not going to be anything other than just a payment that we'll figure out where that falls amongst everything else. I'm going to reserve on fees today just simply because I don't know what all the finances are. I tried to work my way through this and it was quite baffling, but so he'll need to do that by Thursday close of business, transfer to her $2,000, and then we'll sort out how that gets credited.
Very well.
Set it over 2 weeks to the 28th at 1 o'clock.
Very good. Thank you, Judge.
Thank you.
Mr. Zandy, do you want to do a bench order on that?
Sure. $5 years.
What's it?
Losing 5 years.
Good practice for you. Mr. Zandy will do a short bench order, 2,000 close of business by the 16th.
Okay.
Then set it over the 28th.
Thank you.
Right, I believe that is our docket today, so we will adjourn.